What is it that people mean when they talk about estate planning? Today you're going to find out. I am Christopher Small. I'm the owner of CMS Law Firm. We do estate planning, we do probate, we do it well. If you have questions about this or anything else related to estate planning, cmslawfirm.com. Ready to get into some estate planning 101? Let's go. So the way I usually describe estate planning is I say an overarching thing that covers you in two circumstances. Circumstance number one is if you are alive but incapacitated. So think like you're in a car accident and you're in a coma, or you are elderly and you have dementia. Okay, the things that are going to cover you there are going to be power of attorney. Power of attorney is basically who can step in and manage your day-to-day life. Usually this surrounds finances, paying bills, just doing stuff like that, day-to-day stuff. Typically, if you are married, it's a spouse first, and then you have a backup in case something happens to both of you. No spouse, you just pick someone you trust. Number two is medical power of attorney. It's kind of the same thing as the regular power of attorney, but it covers you specifically for medical decisions. Usually spouse first, then a backup in case something happens to both of you. Number three, health care directive. This is basically a document that tells the world what you want to do if you are in a vegetative state. Do you want to pull the plug or not? It tells your medical power of attorney what you want to do, so there's no confusion. It's very clear and no one's fighting about it. If you have kids, you will also typically do a minor power of attorney and minor medical power of attorney. The way I describe these is like temporary guardian designations, okay? If you are in a car accident in the hospital for 3 months, who can step in and act as that parent? Sign a field trip slip, take a kid to a dentist, do parent type of stuff. That is the alive side. For most people, that makes pretty good sense. If you have questions, leave a comment. I will answer that. The other side of estate planning is what most people think about when you think of estate planning, and that is when you die. Okay, so on that side, we are going to have disposition instructions, which are like burial instructions, and you're going to have your will. The will is going to do a couple of different things. First, it is going to name your executor. If you are in a state like we are in Washington, they call it personal representative. I have no idea why they don't just call it executor. They just want to be different or something. This person is generally in charge of administering your estate, gathering your assets, determining your debts, paying your debts, distributing your assets. Will also, if you have minor children, is going to name your long-term guardian. This is super important because if you don't pick your guardian in your will, a court is going to pick for you. And we all have that family member that looks good on paper, but that we would never want to have raising our kids. If you're watching this and you're my family, by the way, it's not you, it's somebody else. And then the will also is going to outline distributions. Who gets what? Pretty straightforward. Now, all of those things together I would consider to be a foundational estate plan. Everybody should have this type of planning done, whether you have kids or no kids, a lot of money or no money. These are going to cover all of your most basic needs, protect your family, and make sure the people that you want to get your stuff actually get your stuff. There are a couple of limitations, though, to the foundational plan, which as part of this estate planning 101, I want you to know. Also going to answer a very important question is, do you need a trust? That's what we're about to talk about. The first limitation with a will is typically when you have a will, you're going to have to go through probate to transfer your property to the people that you want it to go to. Will or no will, you still have to go through probate. Probate is this process, literally, of transferring your property to someone else. It is court supervised. It usually requires an attorney. It kind of costs a lot of money. It kind of takes a lot of time. It's something you want to avoid if you can. That's limitation number one of the will. Limitation number two of the will is you can only do direct distributions. This can be a problem if you have minor children. This can be a problem if you have people with disabilities that you want to take care of. This can be a problem if you just don't want people getting all your stuff and just burning through the money. The solution to both of these problems is a trust, a revocable living trust. The way I describe a trust is like a box. While you are alive, you are everything to this box. Okay, you are the creator of the trust, you are the trustor, you are the manager of the trust, the trustee, and you are the beneficiary of the trust. While you are alive, you can move things in and out of the trust, you can change the trust, you can do whatever you want with this trust. You can revoke the trust. But when you are gone, everything that you put into the trust is going to avoid probate. Mostly this is real estate, business interests. We use beneficiary designations for financial accounts. Everything is going to pour into this trust and you're not going to need probate. Why? When you are gone, the trust still holds those assets. There's no reason to transfer them. So there's no need for court. There's no need for probate. The other thing that a trust does, which is quite nice, is it gives you a lot of flexibility for distributions. For example, If you have minor children, like I do, you might say, if I die, I want the trustee of my trust, who I will name, to manage these assets and make distributions on the following schedule. Until my kids turn 25, I only want distributions made on a discretionary basis for health, support, education, and maintenance. What does this mean? Let's say one of my kids goes to college. They'd say, hey, trustee, I'm going to college. Trustee would probably say, congratulations, and cut a check to the school. Clearly education. Say, hey, trustee, I'm going to college. I need a car. I want a Ferrari. Trustee would say, you can have a Jeep. So we have some discretion over how this money is used to make sure that it is sort of provided the best opportunity possible. Then my trust says when the current kids turn 25, they can have up to a third just by asking. When they turn 30, they can have 2/3. When they turn 35, they can have as much as they want. Allows for some maturity, allows for them to also use the assets for things they might want to: buy a house, start a business, take a trip to Cabo, whatever. But at 25, at 30, at 35, they're going to be more mature, at least in my reasoning, and be able to do that. A trust allows you to do this. A will does not. That is it. Estate planning 101, what people talk about when they say estate planning, what an estate plan is, that's it. Okay, hopefully this helped. If it did, that's great. If you want to talk more, go to cmslawfirm.com. I am Christopher Small, by the way. I'm the owner of CMS Law Firm. We do estate planning, we do probate, we do it well. Thank you for your time. Thank you for your attention. Appreciate you. I'll talk to you again soon. See ya.